In a move that shocked many legal observers, 18-year-old Kyle Rittenhouse took the stand today in his own defense. During his testimony, Rittenhouse claimed that the first man he shot and killed, Joseph Rosenbaum, was holding a chain at one point and threatened to kill him twice during a night of riots in Kenosha, Wisconsin last summer. Watch.
During the evening, was there any friction between your group and protesters slash rioters?
No. The only type of stuff that happened was the person that attacked me first threatened to kill me twice.
In another dramatic moment, Judge Bruce Schroeder admonished the prosecution for what he described as a grave constitutional violation after Assistant District Attorney Thomas Binger questioned Rittenhouse about his silence in the days following the shooting. Joining me now is attorney and co-publisher of Human Events, Will Chamberlain. Will, good to see you.
Good to be with you, Buck, as always.
So even non-lawyers pretty much knew across the board that it was an unusual move, a surprise for a lot of folks, to put Kyle Rittenhouse up on the stand. Why do you think this happened? Why the defense decided to do this, or perhaps Rittenhouse decided on his own to do it?
It looks like my understanding is that it actually was a defense plan. And I've read some things from some experienced criminal defense lawyers that is in self-defense cases in particular, it can make sense to put your defendant on the stand because they ultimately will need to explain, or there will need to be a narrative of them explaining why they felt like they were facing deadly force like this. And they're, I guess, in the best position to do it. I think it's obviously still risky because you open up the possibility of something going wrong on a cross-examination. And there's also the fact that we've had so many prosecution witnesses basically explain the self-defense case pretty clearly. But I think that's part of the reason. And another issue is perhaps the defense calculated that these prosecutors were actually quite incompetent and would not be able to take advantage of the opportunities cross-examination provided them, which seems to be the case. We've seen more of the judge lecturing Binger for really basic, horrible mistakes, the kind that actually can lead to mistrials. And there hasn't been any kind of gotcha that I've seen. I've been watching all of the cross-examination of Rittenhouse, and I've yet to see Binger get really anywhere, any traction on disproving self-defense.
I mean, what were your thoughts when the prosecutor seemed to be leading into you play to Kyle Rittenhouse, you play Call of Duty and other first-person shooter games, therefore, well, what? I mean, what's that supposed to mean?
It's laughable, and you got to figure that among the 12 people on the jury, there's at least one person who's played a first-person shooter. I mean, it's only the most common video game in the world. Fortnite was the most popular video game. Now it's Call of Duty. I mean, these are extraordinarily common things, and it's laughable to suggest that they contribute to like people going on a shooting rampage, which Kyle Rittenhouse didn't in the end. I mean, it's irrelevant, and it's both irrelevant and silly. So I didn't think it was very helpful to the prosecution at all.
The Rittenhouse defense asked Governor Schroeder to consider a motion to declare a mistrial with prejudice today. Can you just first tell us what led up to that, and then we can get into what it would mean?
Well, I think two basic things led up to that. The first is mentioning Kyle's silence, and it's a very standard rule that in order to preserve the Fifth Amendment right to self-incrimination, you can't use someone's failure to testify in their own defense against them. So you can't even bring it up. It's a really, really basic rule in criminal proceedings that prosecutors cannot bring up the defendant's silence or refusal to talk. It can't be brought up. Jury shouldn't be aware of it at all. And then the second thing Binger did was he brought up essentially a topic that had been covered and essentially that the judge had ruled would be inadmissible in a motion in limine, which is like what's called in limine means at the threshold. So it's a motion that happens right before the trial to determine whether or not a piece of evidence could be admitted and seen by the jury. I think it was a piece of evidence relating to, at one point in the past, Kyle had talked about wanting a gun to defend property or something like that. And the judge ruled that that's what's called so-called propensity evidence, the theory, and that it wouldn't be admissible because propensity evidence is unreliable but prejudicial in the sense that it can lead the jury to make mistakes.
Here is the judge getting pretty feisty with the Assistant District Attorney Binger, who is the prosecutor here, for questioning Rittenhouse about his Fifth Amendment rights, or bringing into question his Fifth Amendment rights. Watch.
Why would you think that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, well, I'll leave it at that. So I don't know what you're up to.
It kind of sounded like the judge was about to say it gives grounds for the defendants to declare a mistrial. Am I reading that right?
Yeah, I think that's exactly where his head was going. And I think that was even before. I'm not sure. I'm pretty sure that was before the defense actually formally moved for a mistrial.
Yes, it was before. Yeah.
So yeah, I think the judge knows that he's actually going to have to go and do the research, right? There's some mistrial motions you can just deny because it's, obviously you don't have to get random mistrial there, but he's really going to have to actually do some reading and make sure that the case law would allow the trial to continue under these circumstances where you have a prosecutor, who's intentionally bringing up a defendant's silence. And something else really dramatic. I don't know if you caught this, but there was a point where Mr. Binger was saying that he was trying to assert that he had acted in good faith in trying to do both of these things. And the judge was like, I don't believe that. I don't believe you acted in good faith. That's it kind of went under the radar a little bit, but that's an unbelievably dramatic thing for a judge to say to a prosecutor, basically accusing the prosecutor of lying. And it's also very relevant to the mistrial question because, we're kind of falling into the next part, but a mistrial with prejudice is where if it's granted, Kyle can't be retried. That's the end, right? He is effectively exonerated. There will be no further trial of Kyle Rittenhouse on any of these charges. And one of the standards for granting it with prejudice, so-called, is whether or not the prosecutor is acting in good or bad faith.